Good afternoon, everyone. So welcome in joining us in this very important day in the history of the Hong Kong virtual asset industry. My name is King Leong, head of FinTech at InvestHK. And today I have the architect, the person very responsible for the design and also the unveiling of the AMLO, the VASP regulatory regime, Elizabeth Wong, the head of FinTech and also the director of licensing of SFC with us today. Again, I cannot tell you how excited we all are about this very important day that this is finally going live. And I'm sure that just from talking to a lot of industry players, that there's still quite a lot of questions about the details of this new regulatory regime. So perhaps without further ado, perhaps I can invite Elizabeth, the architect, to help us understand, basically unpack these very various aspects of the AMLO regulation. So with that, perhaps can start with, so with the latest AMLO VSP regime, how is that different from the sort of the traditional sort of Type 1.7 regulations?
Right, so excuse me, to give a bit of a background, the SFC has been regulating virtual asset activities since 2018. So we already actually have an existing regime for centralized virtual asset trading platforms, which trade security tokens. Now, as most virtual assets are not security tokens, they're non-security tokens. So we filled this gap in our powers by implementing a new licensing regime under the Anti-Money Laundering Ordinance. So the regulatory requirements under the new regime actually derive from the existing SFO regime. And now that the new regime has become effective, actually the SFO regime and the AMLO regime will run in parallel. So it's important that the requirements under both regimes are the same. Now, what we've done with the old requirements from the old regime, we have consulted on it in February. We've concluded the consultation in May. We have made some enhancements and some modifications. Now, there will be a slight difference from the previous requirements, but now that we've implemented the new requirements, it's across the board the same for both Type 1, Type 7 licenses and also the AMLO license. So the requirements that we have are actually designed from an investor protection perspective. So for example, there are conflicts of interest requirements. So because we generally expect these trading venues to be neutral in the dealings with their clients, so we don't allow proprietary trading or market making activities on a proprietary basis. We also have requirements of safe custody of client assets. So as with all licensed corporations that are licensed with the SFC, fundamentally, we require them to make sure that client assets are properly segregated from house assets. So this requirement also applies to virtual asset trading platforms. In respect of these particular risks in relation to safe custody of virtual assets, we also require them to have private key safe management controls. So these systems and controls are very important because they prevent collusion or misappropriation by employees. Now, to further address virtual asset specific risks, we also have additional requirements governing the proportion of client assets that can be held in the hot wallet and also in the cold wallet. We also have requirements in relation to auditing and accounting. So we require these trading platforms to submit audited financial statements and also an auditor's report on compliance with the regulatory requirements annually. So we will be receiving these reports annually and we will be reviewing when we receive them. There's also financial resources requirements. So in addition to the requirements that are already applicable to Type 1 and Type 7 licensees, we also require 12-month liquid operating expenses. Other requirements include anti-money laundering, market surveillance, and also various internal control measures, because we saw the crypto winter was partially as a result of excessive risk-taking by firms. So the major difference under the new regime, and which we will allow for also under the SFO license, is that we allow retail access. So I think when the SFC made this decision, we prudently made this decision, and in parallel, we decided that we needed to impose additional investor protection measures. So additional investor protection measures imposed include at the KYC level, at the Know Your Client level, we require platform operators to ensure suitability in the onboarding process. We have also introduced specific requirements for token admission if tokens are to be admitted for retail trading. So these specific requirements are on top of the general requirement that we ask platform operators to conduct due diligence on all tokens before they can be admitted for trading. And finally, another new kind of enhancement that we've made is that we've reduced the compensation arrangement coverage requirement over client virtual assets held in cold storage to 50%. So we've reduced the requirement. So hopefully this will help make the business even more sustainable.
Great. Well, I'm sure that there are a lot of details that perhaps the audience online may not capture all of them. And also, I've been seeing quite a lot of people still coming in. So in case for those of you who have perhaps joined us in the past few minutes, may have missed the early beginning of the sharing from Elizabeth, feel free to drop us some messages under Q&A, and we will try to address them towards the end. Probably we'll leave about 15 minutes, around 2:45, so that we're going to have a more interactive Q&A. So with that, perhaps I guess I would ask another question on behalf of the industry stakeholders, and that is around ROs, the responsible officers. Obviously, this is a relatively new industry, and there aren't, compared with the traditional finance, there aren't as many qualified ROs. So can you elaborate a little bit more about what's the expectation in terms of the qualifications of the ROs?
Right. Now, in terms of responsible officers, we have implemented requirements that are consistent with the existing licensing policy for all intermediaries licensed by the SFC. So in terms of responsible officers, they need to possess relevant industry experience for at least 3 years over the past 6 years. So, and also because due to the possible change in the classification of a token from a non-security token to a security token or vice versa, we think it's appropriate for virtual asset trading platforms to apply for dual licenses under both the SFO and also the AMLO. Now, due to this proposal, we understand that there is a lack of talent of people or responsible officers who have both securities and virtual asset experience. So the SFC is prepared to adopt a pragmatic approach. So for responsible officers that only have virtual asset experience, if their experience is in dealing in virtual assets, then this experience can be considered as relevant for their Type 1 license under the SFO. Should we grant a Type 1 responsible officer license to these responsible officers, we will be imposing a licensing condition on the SFO license, such that this responsible officer can only provide Type 1 regulated activities for the business of the virtual asset trading platform. Now, for the other way around, for responsible officers who only have securities experience, then the experience in dealing in securities will be considered as relevant to the regulated activity of providing a virtual asset service under the Anti-Money Laundering Ordinance. So again, the way we'll be doing this is that we will impose a licensing condition on the RO's AMLO license, so that this RO would be subject to a non-sole condition. Now, in terms of ROs, where they need to be located, do they have to be all in Hong Kong at the same time? Also consistent with existing licensing policy, we only require that one RO is ordinarily residing in Hong Kong to supervise the platform's business. Now, however, there is a slight catch to this because under the deeming arrangement, in order for an RO to be deemed to be licensed, that RO must be performing a regulated function in Hong Kong for the trading platform. So if a VATP applicant wants to rely on the deeming arrangement and also wants to deem the responsible officers, then they need to pay attention to this requirement. So it might not just be one RO that is in Hong Kong, especially since we do have the minimum 2 RO requirements under existing licensing policy and also under the new regime. So we've published circulars and FAQs on this on the 31st of May 2023. So hopefully industry can take a look at the circulars and FAQs and get more familiar with the RO requirements.
Yeah. I have to confess, I read the documents late at night.
It was published late at night.
Yeah. So I would advise you to be in the audience online to read in the morning. So that will be more helpful. Joking aside. Now, but then I think the one thing that a lot of private sector folks also ask about is retail. And for that, I'm not talking about just the people in Hong Kong, but also international. Because obviously Hong Kong has been under the spotlights by a lot of international media. And they're like, wow. So while a lot of jurisdictions are kind of like shying away from opening this up to retail, Hong Kong steps forward to then open up to retail. So obviously SFC has been holding those standards in investor protection. So I'm sure that there's, I'm sure you have to explain this to a lot of people in various conferences, but can we use this opportunity to also share with the audience about the kind of like the thinking behind SFC in taking this very major step in opening this up to the retail investors? Right.
So we note that there seems to be more international caution in relation to virtual asset activities in general. I think this it should be noted that in all other international jurisdictions, they actually don't ban retail investors. So right now, they already opened the doors to retail investors. Rather, SFC has only just started to allow retail investors. I think the reason why internationally the regulators are exercising caution is because previously they implemented regimes that were only from a payment perspective or an anti-money laundering perspective. So there were absolutely no investor protection measures. So, and that's probably one of the reasons why there were collapses, because if you're only regulated from anti-money laundering, there's no need to, for example, segregate client assets. There's no need to safely custody client assets, for example. So I think it's a little bit different from the SFC perspective, because all along, we've been implementing a regime from an investor protection perspective. So we've already put in place investor protection guardrails all along. We have monitored how it has worked out for PI only kind of business. And before we made this decision, we also implemented additional investor protection measures so that we think that retail investors can get more protection under our regime. Although we did allow retail access, I think I also need to emphasize something that although it took effect on June the 1st, 2023, so far we have yet to approve any virtual asset trading platform to provide services to retail investors. So which means that most platforms that are accessible currently by the public are not regulated by the SFC in any way. And we also indeed want to emphasize that by licensing a virtual asset trading platform, we don't guarantee any profits. We don't guarantee that the platform won't go bust, but hopefully by complying with our requirements, we can reduce this risk. So we need retail investors to understand that they may suffer losses, and it's important that they understand it. So the SFC will continue with our investor education efforts and hopefully raise investors' awareness in this connection. Now, in terms of retail access, as I said, we imposed additional investor protection measures. So one key investor protection measure was to implement suitability in the onboarding process. So this is in addition to assessing a client's virtual asset knowledge. So what platform operators need to do now is that they need to risk profile their clients and also set an exposure limit based on the client's financial situation and personal circumstances. So this obligation is on platform operators. There is no hard limit. We have not prescribed a hard limit. So this provides flexibility to platform operators and also enables the calibration of that limit based on the particular circumstances of a client. The outcome of this requirement is that we want platform operators to ensure clients can reasonably assume the risk and bear the potential trading losses in virtual assets. Now, another requirement that we've imposed is in relation to token emission. So we note that there are thousands of tokens available in the market currently, and definitely not all. Indeed, probably most of them are not actually suitable for retail trading. So this is also coupled with the fact that the SFC doesn't actually regulate the virtual asset itself. we only regulate virtual asset activities. So therefore, we impose general and specific token emission criteria through which only large cap virtual assets, which are highly liquid, can be admitted for trading by retail investors. So we've placed this burden on the platform operator to ensure compliance and to conduct robust due diligence. And we also require the platform operator to monitor these tokens so that they can take into account any market developments and any changes to the token. And finally, we require them to set up a token emission and review committee, which precisely is to ensure that this ongoing monitoring process is carried on, to ensure that robust product due diligence has been carried out. And we are looking for a robust process which is documented. So we want to see that this internal token emission and review committee will meet regularly to discuss token issues on an ongoing basis. So we hope that through these kind of measures, we can provide more protection for retailers.
Yeah, I think that those are, again, I respect a lot about the work that you guys are doing, because in a way, we've heard both sides, that the private sector have been expecting a lot, but then they also recognize, well, I think they may not fully recognize or appreciate as much the balance that you guys are trying to strike. Because on the one hand, I think we just had this conversations earlier about why wouldn't SFC have very specific prescription of how much exposure should the retail investor be exposed to. But again, to your point, I mean, different people have different circumstances. So again, it's very hard to draw a hard line. So in many ways, I think the current regulation, at least the principle, is more principle-based, so that you can leave some wiggle room for the operators to basically carry on the business. So in a way, I'm sure that this may have some questions from the audience. Again, please feel free to send us your questions in the chat box. Now, so perhaps I guess I'll ask another very popular question, and that is the deemed to be licensed arrangements for the existing VA trading platform. So again, I think you've been working very late to issue that circular about the transitional arrangement. Can you sort of share with the audience about the highlights of that transitional arrangement?
Right. So the circular that we issued is actually based on what is actually in the law. So in the AMLO, there is actually a transitional arrangement that has been provided for pre-existing virtual asset trading platforms. So these transitional arrangements include a 12-month non-contravention arrangement and also a deeming arrangement, whereby after June the 1st, 2024, certain virtual asset trading platforms can be deemed to be licensed and operate in Hong Kong, such that they won't contravene the licensing requirement. So the intention behind these transitional arrangements is to provide reasonably sufficient time for virtual asset trading platforms that are already operating in Hong Kong and prepared to comply with their requirements, to allow them to apply for a license and also to review and revise their systems such that they can comply with our requirements on June the 1st, 2024. So we've also made it clear that for those who don't want to apply, they should proceed to an orderly closure, and we do not expect them to continue active marketing of their services to Hong Kong investors. So to be eligible for these transitional arrangements, you must be a pre-existing virtual asset trading platform. So what we mean by a pre-existing virtual asset trading platform is that you need to have meaningful and substantial presence in Hong Kong before June the 1st, 2023. So that deadline has passed already. Now, what we mean is that we're looking for a genuine business, a genuine presence in Hong Kong. And we have set out some factors that we'll be looking into. For example, whether you're incorporated in Hong Kong, whether you have a physical office in Hong Kong, are the key personnel in Hong Kong who are responsible for operating this business. So we've made it clear too that the mere setting up of a company or just having shell operations in Hong Kong would not be adequate. Now, for these pre-existing virtual asset trading platforms, they have until the 29th of February, 2024, to submit a licensing application to the SFC. Now, you need to be aware that it must be a fully completed license application. If it's not fully completed, then we will be returning the application. So industry needs to pay attention to this fully completed requirement. And by fully completed, we also expect that the submission would include the first phase external assessment report. So that report is to assess whether the internal controls, internal systems, all the policies and procedures have been designed effectively to comply with our requirements by June the 1st, 2024. Now, when we receive the application, then we will, of course, start our application process to really look into the application. Now, if we consider that the applicant does not have a reasonable prospect of complying with our requirements, or we actually don't think they were actually operating in Hong Kong before June the 1st, 2023, then we will be issuing a no deeming notice. Now, by issuing this no deeming notice, that platform operator will need to close down their business by May the 31st, 2024, or by the expiry of 3 months from the date that we issued the no deeming notice. However, if we consider that the deeming conditions are met, then these platforms are automatically deemed from June the 1st, 2024, until the earlier of when their license application is approved, or they withdraw their application, or we refuse their application.
Well, so that means, I think just now you emphasize the word genuine. So basically that means that if the operator doesn't have any clients, they just merely set up a company, so that wouldn't count, right? Yeah,
that wouldn't count. I think I need to reiterate the intention behind this whole transitional arrangement is to provide time for those who are already operating in Hong Kong to revise their systems, because we understand that their current systems may not actually be compliant with our requirements. So they can use this transitional period to do that, to make sure that they can comply by June the 1st, 2024. So if you are a platform that doesn't even have actual operations or actual business in Hong Kong, then you don't need this time to review your systems and controls. So for these platforms, we think that they should be treated, and they would be treated as all other license applicants that we currently deal with, which means that they can continue to design their business to be compliant with the requirements while they apply for a license, and they can only commence business when they actually get that license.
Right. Well, I guess in order for the firms to find out whether or not they are on the list of deemed platform or the undeemed platforms, would you put this information on a website? Would you send them emails? So how would they know about it?
Right. In relation to the deeming, they will be automatically deemed from June the 1st, 2024. I think probably during the process, we will be in touch with them. And ultimately, it would be likely that we would inform them that they are deemed now on June the 1st, 2024, but that will be down the road when we deal with it. I think for whether their name appears on the deem list, then that is also one way for them to check their status. However, the deeming list, the reason why we are putting it on our platform, on our website, rather is to inform the public as to the different kind of regulatory statuses of virtual asset trading platforms that are accessible by the public in Hong Kong. So we said that we would be publishing a list of licensed virtual asset trading platforms, and that has already gone live. So that is already shown on our website. We will be having an unlicensed list. So that list is to inform investors of trading platforms that we know are what we suspect are carrying on business illegally in Hong Kong or actively marketing to Hong Kong investors without a license. And for the deemed list, we will also tell the public that although they're deemed to be licensed, we actually have yet to formally approve their license application. So we hope through this kind of information channel, the public can find out more about the platforms that are dealing with.
Well, again, I'm trying to think about the different scenarios. So in a case where the platform thinks that they should be deemed, but somehow they are on the non-deemed list, is there any kind of like appealing process? So what can they do, basically?
Right. Before we actually put a name on a unlicensed platform list, for example, we definitely will have our due process. We will definitely reach out to the platform. We will ask them to satisfy us why they should not be placed on this list. So there is definitely a process that we will go through. However, if we're not satisfied, then their name will be on that list.
Okay, I think that this hopefully this is clear for the audience online. Another question that actually came up quite a lot is how long would that take? Because sometimes I think this is very close-knit community, as we all know. Therefore, people talk, right? And they'll try to sort of benchmark against the lead time taken by the previous operators in getting licensed. So then the question is, so how long would you anticipate with lead time, assuming they've already submitted all the correct documentation? So how, do you have a suggested lead time?
Right. So over the past few years, we do acknowledge that the assessment process for a license application for a VATP license has typically been longer than the general license applications that we receive. So while the longer time can be attributed to the fact that the business model is rather complex, we actually do use a lot of time in looking at the safe custody arrangements to ensure that client assets won't be hacked, for example, and the cold storage remains cold, for example. So we do spend a lot of time looking at those issues. But another reason for the application process to take quite a long time is that we have observed that these applicants, in general, do not fully understand the SFC's expectations, regulatory expectations. So what we've done in the consultation and what we've adopted is that we propose that to streamline the application process, platform operators need to submit an external assessment report. So we hope that this external assessment report can help us in our vetting process, because at least a properly qualified external assessor who has the expertise to look at the business has actually looked at it, has looked at the internal controls, has looked at the policies and procedures, and is of the view that these policies and procedures can comply with our requirements. So that hopefully can expedite the process a bit. And I think for tips for virtual asset trading platforms, they really need to understand our regulatory requirements, understand where we're coming from, why we've imposed those requirements, and they should also make sure that their applications are full and complete. So we hope that through this external assessment report and also through more understanding of our regulatory expectations, then hopefully the processing time can be expedited.
Well, perhaps I'll ask on behalf of some international operators. So if they need to get this external assessment report, who can they go to? I mean, for people who are not from Hong Kong.
We just look at whether the external assessor has the qualifications and capabilities. So we don't have like a set defined list of approved external assessors, for example, and we don't think it's appropriate for us to do so either. But if the industry has any like concerns as to which external assessor that they should be employing, we actually welcome them to contact the FinTech unit through the FinTech contact point to just let us take a look at the capability statements, for example, to see whether that external assessor is properly qualified.
Mm-hmm. Okay. Now, so I think in terms of the lead time, you have like a certain number of months as the kind of expectation, and or you rather handle on a case-by-case basis?
It will definitely be handled on a case-by-case basis. And I think that's also one of the reasons why we implemented this teaming arrangement, so that you can continue with your business even when we haven't formally granted a license. So that teaming arrangement is in place so that while we're dealing with your licensing process, you can still actually conduct business.
But this is this is applying on the operators already in business. Yes. But then I think there's another common question, and that is from the overseas operators. They are very interested about applying the license in Hong Kong, but at the same time, they are really considering the business aspects. If it takes, say, 9 months, 12 months to get a license, then they can plan accordingly. But if it takes longer, then they may have other considerations. Right. So this is also in some ways affecting the overseas players in deciding to set up in Hong Kong. So do you have any advice for particularly the overseas players interested about the application?
I think they can start looking at our requirements to see if they're prepared to comply with them. Because as I said, overseas regulations, they focus on payment, they focus on anti-money laundering. They don't necessarily focus on investor protection. So I think first and foremost, they need to be prepared to be able to comply with our requirements. So I think they should start with that assessment first. So whether they are prepared, and then they could take it forward from there.
Mm-hmm. Okay. Now, I think the other thing that, in fact, our colleagues, because we have, as you know, we have a kind of media team, PR team. So they've been tracking some of the media coverages. So one of them says that, Hong Kong, again, because of I think we have a heavy problem, that there's just so much positive reaction to the virtual asset policy announcement, that there's a very overwhelming amount of interest. But of course, I think the flip side of that good news is that there'll be a lot of people applying at the same time. And so do you have any thoughts that can share the audience about how, because I think you guys probably kind of anticipate this too. So how are you going to manage all these like spike of interest in applying?
Internally, we are trying to see what we've done is that we've actually sort of expanded our team so that there will be more people who are dealing with applications. We've also got additional headcount from the government, so we will be recruiting more members to our team. And I think another way that we were preparing for this, because it will be happening, is that we implemented that external assessment report kind of requirement. So hopefully, with the combination of all these, we will be able to continue with a smooth application process in line with what we've been doing for all other license applications.
Okay, I hope that this can address a question from the audience too. Now, another pretty popular question too is about custody. So I think at the moment there's I think there's a word, associated entity in handling the custody. But then I think for a lot of traditional finance, the custody is like a third party, right? So can you elaborate a little bit about how should the applicants look at the custody arrangement?
Right. Currently, we do indeed require all the assets to be held in the associated entity of the platform operator. And this associated entity must be a wholly owned subsidiary of the platform operator. The reason why we have introduced this requirement, it's not in line with existing requirements for traditional finance, because currently we also have this associated entity concept for our brokers. And what happens is that securities held on behalf of a client is actually held by the associated entity. It's just that we have, for example, we have CCAS, which is this the custodian for securities traded on Hong Kong Exchange. So in our scenario, we don't have a CCAS, but we still keep it so that the associated entity puts the current assets. Now, the reason why is because the SFC doesn't regulate custodians. It traditionally hasn't regulated custodians, but we will have a new kind of depository license, but that depository license is only for SFC authorized funds. So before we have the power to regulate custodians, or before custodians of virtual assets are regulated in Hong Kong, whether by another authority or otherwise, we need to ensure that we have proper regulatory handle over the custody of client assets. So that's why we require it to be held with the associated entity, because we can go in if there's anything that happens to the custody of assets. So that's the reason why right now we have kept it with the platform operator. And also we have taken into account the fact that there seems to be a limited availability of qualified traditional custodians to provide custody services in virtual assets. So I think we will be we'll be monitoring developments in the industry. We'll be monitoring developments as to whether custodians will be regulated. And then when that time comes, then we would be able to see how we could review and revise our requirements.
Now, so for this associated entity, do they apply through at the current setting? Because in Hong Kong, the trust company, the TCSP, would apply the license from company registry. So under this associated entity arrangement, so do they need to get a license? And if so, is that the same arrangement like the CR?
Yes, under our proposals, or under our requirements, we do require the associated entity to get that trust company and service provider license from the company's registry. So that is one requirement that associated entities need to comply with.
But how about, actually my colleague asked me to ask you too, about that newly regulated activity of Type 13. Is that relevant in this conversation?
That's not relevant because the Type 13 regulated activity only applies to depositories of SFC authorized funds. So if you're not a depository for an SFC licensed fund, then an authorized fund, then you do not require a license.
Okay, got it. Now, perhaps we'll quickly change gear because we have quite a lot of things to talk about. Okay, now, so let's quickly talk about the coin offerings. So in terms of the digital tokens, under the definition of securities, now, so how would you define, or would that be considered as a regulated activity for those digital tokens?
Right. So it all depends on the features of the digital tokens. So if that digital token has features of a security, then it would probably be a security token. And once it's a security token, all activities in relation to that token will fall within the SFC's regulatory remit. But if it does not, then actually the SFC does not regulate the issuance of these tokens. So we previously, when there was this ICO kind of popularity, we issued a number of warnings to investors because a lot of them turned out to be scams, which was good that we issued these kind of warning statements. But currently, recently, we haven't noticed any prevalent ICO activity anymore.
Because I think in many ways, sometimes these operators, they are not even in Hong Kong, but yet they're targeting the Hong Kong customers. So would that be considered illegal, or so what was the SFC's stance in looking at this? I think it really depends on whether it's a security. So once it's a security, then we have our full powers, and active marketing of a investment or a security to Hong Kong investors is definitely an offense. It's an unlicensed activity in Hong Kong, and that would be something that we could go after. But if it's not a security, then it really doesn't fall within our regulatory remit. Okay. Now, so let's talk about another hot topic. It's on DeFi. Now, so in fact, I think your colleague Keith also spoke about DeFi, SSC view on DeFi in numerous events. So can you share again to this audience about SFC view on DeFi? Right. We do note that DeFi has grown in popularity in recent years, but we also acknowledge that it is actually quite a difficult sector to regulate because it is run over smart contracts and there's no apparent legal person or entity in charge. So therefore, these activities don't really fit neatly within our regulatory remit, which was designed to regulate conventional financial markets with centralized entities. So we are also grappling with the difficulties in regulating this space. But then we are also a member of the IOSCO FintechHK Task Force. And IOSCO is actually looking very closely at how DeFi should be regulated. So we are working very closely with other global regulators to see when and how to come in to regulate this space. And in particular, we know that actually some DeFi protocols are actually only decentralized in name only. So in reality, they are operated by a small group of developers or related parties may have de facto control. So if we are able to identify these parties, it may be something that we could start looking into. So it is important for, I think, DeFi operators to look through their actual substance of the DeFi arrangements and to think about how they can be actually regulated as well. So we will assess service or activity on a case-by-case basis. Okay, thank you. Now, another one is NFT. I'm sure that this came up so many times. Now, I think in our previous discussion, I think you made it very clear, if this is truly non-fungible, that's not under SFC's remit. But yet, there's been so much innovation that people are like fractionalizing the NFTs and so on. So can you again share to the audience about how you see the evolution of the NFT products and what version of NFTs will be under the remit of SFC? Right. We have been closely monitoring the developments in the NFT space. So we previously issued a statement. So only when in
NFT falls under the definition of security, do we have regulatory remit? We also clarified that if, for example, it's a genuine digital representation of an artwork, for example, which was how NFT started, then that really wouldn't fall within our regulatory remit. The reason why we also said that if you fractionalize it, it might start to become a security is because once you fractionalize something, there might need to be management of the underlying asset. So once there's this management concept, you might actually fall within that collective investment scheme definition that we have under the SFO, and such that those tokens would then become security tokens, and then it would be subject to our remit. But the thing is that we need to look at each NFT on a case-by-case basis. So each NFT, you need to really go ahead and assess whether it will fall within the security definition or not. And for those that do not fall within the security definition, we're not saying that it's definitely not regulated. I think it's just not regulated by the SFC. And I think the government also, from time to time, looks at these activities and to see whether other kinds of regulations are appropriate. For example, copyright law. I'm not sure how that would apply to artwork that are in an NFT form, for example. So there are a lot of different angles to NFTs. The SFC's perspective is only when they are securities will we be regulating these activities.
Well, in fact, there are numerous players, some locally from Hong Kong, some from overseas, and they are even from India and China, believe it or not. In fact, they already have an existing NFT business, and some of them are from large companies, and they want to be regulated by SFC. So if they want to be regulated, do you have any advice about how they can sort of structure the NFT business so that they can be regulated by you? Because they want to. It's not that they want to sort of be doing things, in a sort of like a dodgy way. So do you have any advice for them?
I think we need to stick with SFC's regulatory remit. It's not just because somebody wants to be licensed, then we can actually license them. So it really depends on whether what the activity they are doing would actually fall within our regulatory remit. If it does not fall within our regulatory remit, there is no license that is available. So in a way, if NFTs are really just genuine digital representations of artwork, for example, it's just like SFC doesn't regulate art galleries. We shouldn't be regulating NFTs in this regard. So I think it's good that we are clear as to what should be regulated and what should not be regulated, by us at least. Mm-hmm. And I think for any NFT platform, they should also carry out this kind of assessment.
Great. Now, I think maybe one last question before I go to, wow, we have quite a lot of questions. Wow, look at this. Okay, so let's ask one last question before we go to the questions from the audience. So I think that a lot of people are also wondering, because obviously the government has put a lot, government, particularly SFC, has put a lot of energy behind the centralized exchange regulatory regime that went live yesterday. So, but then can you sort of share with the audience about why you chose the centralized exchange as a starting point where we put so much resources and energy, but not the other VA activities?
Right. I think we need to give a little bit of background to this because back when the government did its consultation on the regulation of virtual asset activities, back then trading on centralized virtual asset trading platforms was by far the most prevalent activity in Hong Kong. So, and also, although we don't have any official industry data, we understand from our complaint statistics that most of the virtual asset complaints that we receive actually relate to online scams and withdrawal issues involving virtual asset trading platforms. So that was maybe the background to why virtual asset trading platforms were chosen. For other virtual asset activities, for example, we know that there may be payment systems or custodians. We note that payment systems in particular, as a standalone business in Hong Kong, are relatively limited. And also we note that HKMA also has a consultation on stablecoins. And it seems from that consultation that the regulation of stablecoins may have some overlap and cover some of the activities in the payments or the custodian sector. For OTC channels, although under the AMLO, we do not actually regulate this, we have been actually regulating OTC already through regulating our intermediaries. So For example, for virtual asset trading platforms that are licensed with us, they are already allowed to provide off-platform trading activities. For our intermediaries, under the joint circular that we issued with the HKMA, we also allow them to provide dealing services to their clients. And we also note that, for example, for other OTC channels, once a AMLO new regime has taken effect, a lot of them actually, they need to deal with platform operators at the back end too. So we hope that through this new licensing regime, then their channels to deal with platform operators will diminish, because as more and more platform operators are licensed, they have AML requirements that they need to comply with. And it would be unlikely that they would continue to do business with these kind of unregulated OTC channels. So that was the thinking behind, and that was why we started off with virtual asset trading platforms. However, we do note market development. So we have always been in ongoing discussions with the government in relation to exactly what other activities should be regulated and who should be regulating these activities.
That's great. Now, so I think we have about, of course, I think if we run over, we'll see if the schedule allows us to address all these questions. So perhaps we'll just go through in a first in, first out manner. So the first question that came from perhaps, well, I guess I shouldn't name. So are security tokens also available for retail investors? And so what are the requirements for that?
Right. So for security tokens, if you have a license to, for example, distribute security tokens, then they can be distributed in Hong Kong. The thing is, for retail investors, security tokens need to comply with the existing securities laws in Hong Kong. So for any offering of securities in Hong Kong, you need to either comply with the prospectus regime under the Companies Winding Up and Miscellaneous Provisions Ordinance, or you need to comply with our authorization requirements under the Securities and Futures Ordinance. So before a security token can be offered to retail investors, you need to obtain authorization from the SFC, or you need to comply with the prospectus regime. So before that, it's not that we don't allow security tokens. It's just that under securities law, it needs to be authorized. So and then of course, when you conduct the activity, then you need to be licensed with the SFC as well. So currently, on the basis that no authorization for security tokens has occurred yet, currently security tokens can be offered to professional investors, and as long as you have that license to conduct Type 1 regulated activity in Hong Kong.
Right. Well, so let's go to the same question. I think there's a very specific one. Is it necessary to have a decentralized registrar, like in Germany, to have a central depository to track all transactions after the travel rule between multiple venues? Is this something that you'd like to comment, or any thoughts on this?
I think from the SFC's perspective, we regulate our licensees' compliance with the travel rules. So from SFC's perspective, we would look at whether our licensees, especially virtual asset trading platforms, once they are licensed, whether they are complying with the travel rule, which we have placed in both the anti-money laundering ordinance and also in our AML guidelines. So for SFC, that's the way that we will be monitoring the travel rule and compliance with the travel rule.
Okay. The next one will be, may I know how to ensure demarcation between neutral exchange and crypto trading entities under related group company structure in the context of conflict of interest risk compliance? Right.
So right now, we have provided in the guidelines for virtual asset trading platforms that the platform operator cannot conduct proprietary trades on the platform. They cannot conduct market-making activities on a proprietary basis. And we have also made sure that for any group entities, they also cannot be placing orders through the platform operator. So that's the way how we deal with like different group entities within the same group that the platform operator is.
Yeah, in fact, I think there might be more questions on this because I heard this quite a lot. particularly on market making. So anyway, I guess let's move on. If there's a centralized platform for the trading of NFTs, which do not fall within the definition of securities under the SFO and are denominated and settled in ETH or USDT, as an ancillary service, the platform provides service for retail investors to buy and sell Ether or USDT and settle in fiat currencies such as HKD. In professional terms, the platform provides trading pairs of ETH, Hong Kong D, USDT, HKD. Thus, the platform provides regulated VA service.
I think
it's a long question.
It's a long question, yes.
Yeah.
I think under the anti-money laundering ordinance, the new regime, what we're regulating is a centralized trading platform that has a matching kind of engine to match buy and sell orders. Theoretically, if an NFT is listed on this kind of platform, then we would be regulating the trading activities in relation to that NFT as well. The thing is, NFTs are supposed to be non-fungible. So it would be quite rare that you would actually list an NFT on a centralized trading platform because there's only one NFT. So you just post it on it. It's more like a kind of P2P kind of posting that would make sense. It wouldn't really make sense on our kind of centralized virtual asset trading platform. So unless the NFTs are actually fungible, they're only labeled as an NFT. Otherwise, I think it would be quite bizarre that they're actually traded on a centralized virtual asset trading.
Yeah, because I think they frame the question based on NFT and NFTs. So I think that I understand the logic. Now, maybe I'll just move on in the interest of time. The next question, let's see. I want to develop my fintech startup in Asia. How can I find partners in Hong Kong which can help me with business development and sales networking? Join the Invest Hong Kong events. So I think just follow us, the FintechHK LinkedIn, and this is where we post all the events, and also that you can also find us on LinkedIn. In fact, I would just maybe a colleague can type the fintech at Invest Hong Kong email so that you can also drop us email to find us, and this is where we can help to start your journey. Okay, so let's see. Does a trading platform needs to be in Hong Kong, or is the model fine that the license company is using a trading venue outside of Hong Kong?
Right. So what we're regulating is a centralized virtual asset trading platform with a matching engine. We would allow, for example, a tech company to build the system for you and then white label it and make it part of your company. But if you're saying you are using a other trading venue, then we would need to license the other trading venue and not you. So I think that's the logic behind the whole licensing system.
Right. So I think the key is that trading engine has to be physically in Hong Kong.
It has to be operated by the platform operator in Hong Kong.
Right.
Yeah.
Yep. Okay. Got it. Okay. So let's see. All right. So thanks, Elizabeth and SFC, which I agree is a lot of work. So thanks for breaking through the finish line. Let's see. So there's so much to digest within a short period of time, and I wonder how SFC would pace itself in grants as many licenses for those ready to get more business in how things turn out in practice, or B, further review on some of the key points, third-party custodians, which in our view would improve security if properly qualified, the trading of derivatives, etc. So there are quite a lot of points made by this gentleman. So I think the key question is, since there's just so many things happening, so would you just focus on just giving out licenses and focus on that before looking at the other new developments, such as the ones that this gentleman mentioned? So what was your current planning?
In light of limited resources, we actually do try to do both the policy side and also the application side at the same time. So I actually do have a policy unit as well as processing unit for the applications that come in. We will continue to look at all the outstanding policies that the industry wants to see. I think in doing so, we also need to work with the government. So some of these issues that or requests from the industry really may actually be beyond the SFC. It may need a government kind of concerted effort to get everybody together to work on it, and also to see who the appropriate regulator is. So I think we will continue our efforts. We actually have been doing it a lot already, and we will continue with this.
Well, I think for the benefit for audience online that might not have participated in a recent closed-door meeting hosted by our Financial Secretary, Mr. Paul Chen. So basically at that meeting, we had some representatives from private sector, we had SFC, HMA, some government policymakers, and so forth. And the point I'm trying to make is obviously SFC plays a very important role, but at the same time, there are also other, we call Hong Kong Inc. partners who are also very much involved. So the entire burden doesn't just fall on SFC. So there are other players who are also contributing. So again, I'll move on since there are still quite a few. Wow. Okay, so we'll try to get through as many as we can. If not, we'll try to see how we can address them, perhaps in the form of an FAQ that we can, work with SFC, and then we published through social media, put on our website, and so forth. So we'll work through some of the questions in case we don't get through all of them. Now, so let's look at the next one. Oops. Okay. Where does it go? Thank you. All right. So the next question about liquidity, which also came up a lot, because I still remember I had a conversation with someone about if we define the tokens to be allowed for the retail access purely from trading volume, saying I think Luna used to be one of the top 10 traded crypto. So how do you view the liquidity in terms of, I think, being the ones selected and allowed to be accessed by the retail investors?
Well, we have imposed a requirement that the token needs to be included in 2 acceptable indices. These indices, we expect them to be large cap indices. We'd also look at whether these assets are investable. So through the indices, they also look at liquidity. We are using this index kind of requirement to at least have a baseline kind of comfort in relation to liquidity. Of course, we would expect platform operators to continue to do the due diligence. And we do acknowledge that large cap may not necessarily mean liquidity. Liquidity in terms of trading volume may not really mean actual liquidity. So I think we hope that through the platform operators' kind of due diligence, they would be able to actually spot these issues to see if there are underlying issues with the liquidity. So it may be all fake trading volume, for example. So it all really depends on the platform operators' due diligence.
Right. In fact, I think to that point, I spoke with some platform operators, and they have a pretty savvy like scorecard in deciding what tokens are even tokens that they will entertain themselves. So I got that point. Now, so I think the next question is, I guess somewhat related. So can you confirm that the trading platforms would ultimately determine which tokens that they will admit for trading?
Now, for tokens that are emitted for trading for professional investor clients, we only require a notification to the SFC that you will be listing or emitting new tokens to the platform. For those that are emitted for trading to retail investors, we have implemented a approval process for the admission for any plan to admit any tokens for retail trading. So what we will be looking at is actually looking at the due diligence done by the platform operator. We need to be satisfied that the platform operator has properly done the due diligence in choosing which tokens to be listed before we can actually allow them to emit tokens for retail trading on the platform.
Right. Well, I think this is an important one. So let me turn the question around. So does it mean that for every token that the platform lists, they do not have to go to SFC every single time to get approval before they list the token?
For tokens for professional investors, they do not need to. for tokens for retail trading, then they would need to look. They would need to find us for each token.
Okay, so I hope that this helps the audience. Now, the next question. Well, I think this may not be SFC question, but let me ask it nonetheless. What is the SFC stance on stablecoins and other types of digital assets that are pegged to traditional currencies or assets?
Right. In relation to stablecoins, this is really something that is under study by the HKMA. In terms of tokenized assets, we are actually technology neutral. So if you think that tokenization of an asset can bring about efficiencies or good for investors, we are totally supportive of the tokenization technology. I think when you tokenize assets, and where we would start looking at it is that if you tokenize them, for example, if you tokenize a traditional financial instrument, then because, for example, traditional securities fall within SFC's remit, then we will also be looking at whether you have the proper license to distribute this tokenized security, for example. If you tokenize assets and you fractionalize that assets when you tokenize it, then again, as I was talking about NFTs, you will start to go into whether it's a security token because it may amount to a collective investment scheme. So I think from the SFC's perspective, we are supportive of tokenization. What we look at is whether it would fall within our regulatory remit. If it doesn't, then actually it's not a concern to the SFC. If it does, then we will look at whether you have the appropriate licenses to do what you want to do. And we will also look at the conduct to ensure that investors are protected.
Great. Now, I'm conscious of time, but I also see that the number of attendees are still there. They're still perhaps very engaged. So perhaps if that's okay, can you open
I think I can just take maybe one more question.
Okay, let's take one more, and the rest then we'll try to address them via the FAQ later on. Well, the next one here is what would happen to the brick and mortar OTC crypto shops across Hong Kong? Do they need a license, and can they continue to operate now that the new regime has come into effect on June 1st? And is there any maximum cap of how much money for daily exchanges, transactions for these brick and mortar OTC crypto shops?
Right. So we understand that there may be brick and mortar OTC shops that are actually operating an exchange. So if they're actually operating at the back end a trading platform in Hong Kong, then they would be required to be licensed. So because the new licensing regime is precisely to license, to regulate trading platforms. So for these, then they would need to get a license from the SFC, or else either they can be deemed, or they would then be conducting unlicensed activities without a license. For the others, then currently the legislation does not cover these brick and mortar shops, and I think for any new regulations, this would also be something that the government would continue to look at.
Great. Well, I think we're running the short time, but again, thank you for the attention from all the audience. And just like in earlier efforts, that we also work with SFC and HMA with some of the banks on the bank account opening matter, in which our team work with HMA, who have been super supportive to help us draft an FAQ, so that we're able to distribute via our FintechHK social media, put on the FintechHK websites, and we will do the same. So of course, we go through the questions, and we will try to extract to some of the most common questions, I suppose, because I think not everybody would be interested on some really, I would say, specific matter. So once we go through that exercise at SFC, we'll also publish that via our various channels. Now, so with that, I just want to thank Elizabeth again. It's a lot of hard work. So thanks for getting us through to this point. And I hope that from now onwards, there'll be more active participation from the audience, not only in the central exchange, but also in other aspects in fostering Hong Kong as the major virtual asset hub going forward. So again, thanks for your time, and I wish you a happy weekend. Thank you very much.
Thank you.
Okay, thank you. Bye-bye.